Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
My name is Tim Kelly. I'm an associate at Hausfeld, LLP, where I represent public entities in affirmative impact litigation of a variety of sorts, primarily environmental, including, most relevant for today, water contamination litigation. In today's episode, we will discuss the recent Supreme Court opinion in an important water contamination case, City and County of San Francisco versus EPA. In that opinion, issued in March of this year, 2025, the U.S. Supreme Court struck down the EPA's use of end result requirements for National Pollutant Discharge Elimination System permits, or NPDES permits. In particular, the court held that although the Clean Water Act authorizes the EPA to impose narrative permit conditions beyond just numerical effluent limitations, it does not authorize the agency to impose permit conditions that hold dischargers responsible for overall water quality in receiving waters, which the court held would count as improper end result limitations. In this episode, we will explore the legal reasoning behind the court's ruling and the breakdown of the majority and dissenting opinions, as well as how the decision impacts not just municipal wastewater treatment plants, but also the EPA's ability to regulate water pollution. I'm sitting here virtually with Misha Tseytlin, a partner at Troutman Pepper who drafted an amicus brief that proved influential for the majority's ruling. He's the head of Troutman's appellate and Supreme Court practice and regularly practices before the Supreme Court and appellate courts throughout the country. Thanks, Misha, for joining us today.
Thank you so much for having me.
Before we jump in, I want to make a quick plug for an upcoming event that will be hosted by SEER. It's called the Flow Forward, North American Water Quality Forum. The event is a one-day in-person conference that will occur on May 16th at Detroit Mercy Law in Detroit, Michigan, and will include some outstanding speakers, including our keynote speaker, Judge Judith E. Levy of the United States District Court for the Eastern District of Michigan, who played a pivotal role in overseeing legal responses to the Flint water crisis. I think that's enough for me. Let's talk about the law. Misha, can you start us off with a brief summary of the facts and procedural background of the case, as well as the question that was presented to the court?
As you mentioned, this case deals with NPDES permits, which are permits that companies or municipalities need to have in order to discharge into waters of the United States under the Clean Water Act. Here, San Francisco had such a permit as it was discharging into the Pacific Ocean from its wastewater facilities. The permit had what more traditional conditions about amounts you have to discharge and techniques that San Francisco had to use in order to make sure that the discharges were sufficiently clean under the Clean Water Act. However, it also had end water quality requirements, which essentially says that even if you follow all of the rules about how much you discharge or what the quality of the discharge is, San Francisco essentially could be on the hook if the ultimate water quality of the Pacific Ocean in various respects didn't meet certain end quality requirements. And this was, to San Francisco's mind, very problematic because obviously San Francisco can't control the technologies it puts on its discharges and the amount it discharges, but it is quite challenging, to say the least, for San Francisco to warrant the ultimate water quality in numerous respects for the entire Pacific Ocean, or where it was being measured there in the Pacific Ocean.
So, yeah, thank you for that. The court was pretty graphic in terms of what we're talking about. So just for our listeners, the waste that we're referring to here is untreated human waste that's being pumped out into the ocean, right? And so the court, I'll quote part of Judge Barrett's opinion, where she says that we're talking about discoloration, scum, and floating material, including toilet paper. So that's kind of what we have in mind in this case, and this is being pumped out by the city into the Pacific Ocean. What were the main concerns of the parties as they approached this case?
Yeah, so obviously it's a statutory interpretation case. So the broad fight, and the one U.S. Supreme Court took, was whether EPA, beyond imposing the traditional water effluent limitations, which is essentially what are you discharging, how much, at what rates, could the permit also impose a requirement that the ultimate condition of the water quality of the receiving waters met certain thresholds. And the primary submission of San Francisco was that that kind of condition exceeded the authority of the EPA under the Clean Water Act, and that as a practical matter, it would create an impossible situation for municipalities and industry if they had to warrant the ultimate water quality of the receiving water, such as the Pacific Ocean. There is often multiple dischargers into the body, and so it's quite challenging, and certainly not the way it's traditionally been done. Under the Clean Water Act, the submission on the other side by EPA and its supporters, including the state of California, who in this case was against the city of San Francisco, was that one, they argued that this was permissible in the Clean Water Act, and two, that it was practical because a lot of times it was difficult to spell out all of the specific steps that the discharger would need to do in the NPDES permit sufficiently comprehensively, and that if you had an end water quality one, it allowed the discharger to essentially come up with how it was going to do it, how it was going to achieve the result, rather than having a more prescriptive, detailed requirement. Now, of course, the way it works in actuality is that it's not like these end water quality requirements are put on instead of end fluent limitations in the main. Usually you get the detailed requirements as San Francisco had here, and then you put these on top as well. So it's not really a kind of thing that makes it easier on dischargers, gives it flexibility, like a cap and trade regime or something like that, which is some people advocate for that in other contexts for that reason. So it's an additional, very difficult to comply requirement.
So just to break that down a bit, we're considering three different outcomes for this case, right? So there's the possibility that the Clean Water Act only permits the EPA to impose effluent limitations, which are what you were describing, the kind of the most basic numerical limits in terms of how much of a pollutant you can discharge. And then on the far opposite side of the spectrum, there are these end result limitations, which would be about the actual water quality in the receiving waters. And then the court kind of carves out some middle ground between the two, right? Where the court says that there might be narrative limitations that are permissible, but not specifically end result limitations. So we're not limited to effluent limitations, but the court did not embrace the possibility of end result limitations. Is that right?
That's right. Now, obviously, how one articulates narrative and how broad that category is, is to be decided in future cases. And the court was not convinced by San Francisco's argument that limitations in the relevant provisions had to be effluent limitations. But the category that was so problematic was the end water quality limitations category. And the Supreme Court clearly held, consistent with what the Second Circuit held before and contrary to what the Ninth Circuit had held below in this very case, that you couldn't do end water quality limitations.
Can you tell us more about how the court reached that opinion? You mentioned this as a statutory interpretation case. So what was the court's approach to interpreting the statute at issue?
Well, so obviously, as the court does, it started with the statutory text. And so the case, the word is other limitations. That's the phrase. And the dispute here between the majority and the dissent is kind of a classical textual, not classical, but kind of a very common textual dispute that happens within a textual methodology, which at this point, all justices are using, which is that you have a broad sounding term that is within a statutory context. And the question is as to whether to read the broad sounding term capaciously or whether to read it within the context of the statutory scheme to have guardrails to it. And what the majority said is based on multiple indicia in the statutory text surrounding uses of the word limitations, the overall statutory design of the Clean Water Act. The word other limitations is like, in the main, effluent limitations and not this end water quality results thing. What the dissent argued for is just a broad reading of the word limitation without saying that the context surrounding that word imported this limit that it could not be end water quality.
So as you mentioned, there's several different aspects to the statutory interpretation here. And I think that the majority opinion made some good points looking at the history of the statute and how the current Clean Water Act differs from its predecessor statute. And I think that does support the court's conclusion. But I have to say, I have a little bit of difficulty accepting the notion that the court really embraced the plain meaning of the statute. And that's what Justice Barrett argued as well. In her opinion, she says that the court offers nothing to substantiate the proposition of its interpretation of the statute and that it is wrong as a matter of ordinary English. She continues to say it is commonplace for limitations to state that a particular end result must be achieved and that it is up to the recipient to figure out what it should do. So then she kind of goes into a few examples. I want to talk about a few of those. She talks about the notion that a company can impose spending limitations by requiring each branch to spend no more than its allotted budget, while still leaving the branch manager's flexibility to determine how to allocate those funds. Or that a doctor could impose a limitation on a patient's diet by telling the patient that she must lose 20 pounds over the next 6 months, even if the doctor does not prescribe a specific diet and exercise regimen. So those do seem, I think, uncontroversially like limitations that are being imposed, and yet those are end result limitations that, at least according to Alita's opinion, don't count as the word limitation. So what do you think about the plain meaning here? Is Justice Barrett wrong to say that the court is reading limitation in an excessively narrow way?
Well, I mean, look, this is what I was saying about this dispute. So you certainly can have the word limitation in some context used the way Justice Barrett said, but what the majority concluded was not that the word limitation never could have that meaning, is that within the statutory scheme, where you have effluent limitations and other limitations, where you have other indicia, where the entire structure of the NPDES permit was to move away from the ineffective end water quality limitations regime that existed before the enactment of the Clean Water Act, that is not the best way to read that phrase within the statutory context, both textual and historical, that is found here. I do not think that you could cite this opinion for the proposition that, let's say you had a contractual dispute with a doctor that said you could never give me a limitation, and then he did the Justice Barrett thing, that somehow you breached his contract. You'd think that what this opinion stands for and what the holding is within the context of the Clean Water Act's NPDES permit regime, requiring dischargers to warrant the ultimate water quality of receding waters is not a limitation. I think that's what the opinion's holding is, not that the word limitation in all contexts and for other purposes can't encompass results.
Okay, so the court, like you said, looks to a few different sources to interpret the statute, and in this context, although it did take into account plain meaning in a sense, that plain meaning was maybe weighted less heavily than the structure of the statute and the history of the statute. Is that fair?
I don't think that is the doctrinally correct way to articulate that. If folks remember back with the second Obamacare case, King versus Burwell, where there was, when I said it was a similar dispute there, the U.S. Supreme Court faced an argument that you couldn't, that based on a similar reading where you focus on one particular word, you have one result that was the U.S. Supreme Court held in that case discordant with the entire statutory scheme. You would have one result. But if you looked at that word and that phrase in statutory context, you reach a result that is more concordant with the entire statutory scheme. Obviously some justices dissented in that case, some justices dissented in this case. But reading a otherwise broad or otherwise clear word within the statutory context and with other textual clues and structural clues is an accepted method of statutory interpretation within the textual school. It is not a rewriting of statutory text to reach a particular result. Every justice on the court has signed on to an opinion adopting reading of statutory text that takes context into account. Scalia Gardner, kind of the now canonical statutory interpretation treatise, goes at length about how that is a permissible way to read statutory text. Now, it's also true that I think every justice on the U.S. Supreme Court has dissented in a case where the majority used those tools to take a narrower reading of a broad statutory term. And so it's one of these things when a justice uses those tools to reach a narrow result on statutory text, they point to those permissible ways to read words. And when the justice is in dissent, it always sounds like what Justice Barrett is saying in dissent here. So, that's what I would say.
In this case, the majority opinion talks about, like we just said, the history of the statute. And the predecessor to the Clean Water Act, they explain, ended up being rejected or revised so as to be the Clean Water Act as it currently is, in part because of what the court describes as a multiple discharger problem, which you referenced earlier, the idea that, in these bodies of water, if there's multiple entities releasing pollutants into that water, then if we were to regulate the receiving water's water quality, that kind of fails to capture the ways in which the different discharges are contributing in different ways. And so that's why the Clean Water Act shifted focus to be more about the discharger and less about the discharger, to be more about the discharger and less about the water that's receiving the discharge. In this case, as Barrett said, there's no multiple discharger problem. I mean, of course, we're talking about the Pacific Ocean, which lots of entities are discharging into, but the specific area that the court was focused on was just near San Francisco, and so there was no other source of the pollution here. And yet the majority says that the multiple discharger problem did inform its reasoning. So can you tell us a little bit about that?
Yeah, I mean, obviously, the point that the contested point that a particular problem with reading statutory text this way doesn't apply in the extant case is not generally seen as a relevant method to interpret statutory text that's going to impact industry and municipalities throughout the nation that do have this problem. And the problem is that I think it's quite clear and intuitive why it is a very big and I think insuperable defect in EPA's and Justice Barrett's position here. If the discharger has to warrant and be potentially subject to citizen suit and other types of liability for the end water quality of a body of water, and there are multiple discharges into a body of water, you essentially make it impossible for a discharger who holds this permit and is supposed to be protected from liability if it complies with this permit from ever being assured that it is in compliance. Because you, as say a private party, you have a manufacturer plant, or say you're a municipality, you can only control your own actions. I mean, maybe the municipality can control the actions of a third party if the third party is within its jurisdiction, but it doesn't have to be within its jurisdiction. And of course, if you just have a factory, you can't control what the other factory is doing. So if you're doing everything you can, you've got the most prudent, most state-of-the-art controls possible on your plant, but the folks down the way have some issues. Suddenly, if the common body of water ends up exceeding the ultimate water quality standard, then you could be sued for ruinous penalties for something that you couldn't control. And you can't. Not only could you not put on those controls because you already have a state-of-the-art controls, but further, even if you could put on greater controls or you could shut down your factory to have a stop discharger, you wouldn't know that the other guy is discharging more. So how are you supposed to operationalize that? This case, I don't know, I think it was mentioned at the top. I wrote an amicus brief on behalf of a large number of trade organizations. It's one of the largest groups of trade organizations in terms of the number of members of different kinds of industries that's been filed at the Supreme Court in recent years. And what our members experienced and what our members told the court was that it is just an impossible situation where you have to be held liable and have the state of liability uncertainty based upon actions that you can't even control because other parties are discharging into the same bodies of water.
And so that's the National Mining Association, right? Was the party that you represented?
Well, the National Mining Association was, the first one on the brief, but it was National Mining Association, American Chemistry Council, American Farm Bureau, American Forest and Paper Association, American Gas Association, American Petroleum Institute, U.S. Chamber of Commerce, National Association of Manufacturers, National Federation of Independent Small Business Legal Center, National Pork Producers Council, Southeastern Lumber Manufacturers Association, Fertilizer Institute. I don't read that list to just kind of like say, oh, look how many clients I had. Is just to show that the notion that this is not EPA's position here would not have been a devastating problem, not just for one type of industry, but for industry across the board, is belied by the fact that you had all these industry groups come together on one amicus brief. You certainly have amicus briefs from time to time that you have a couple of groups like this, but to have this many groups from across the entire economy come together and say, hey, this is crazy. There's no way that this long-standing statute should be read to have this anomalous result. This result that kind of breaks the fundamental bargain of the Clean Water Act. I think one of the NPDES permits and effluent limitations, they're serious business. There's a lot of steps and technologies that need to be taken to comply with those permits. And the fundamental bargain of the Clean Water Act for dischargers is you do all of that. But if you do it, and if you don't do it, you can be subject to citizen provisions with significant liability. But if you do it, if you do everything right, if you follow, what you're supposed to be doing, you've got something called a permit shield, and you're protected from liability. The permit shield becomes of very little value to a company as a practical matter if you can't control, based on taking prudent steps at your plant, whether you can be sued, whether you're protected by the shield.
One interesting part about this case is, if I'm correct, it's the first opinion really where the court shows how it's going to operate in the post-Chevron era. So we had the Supreme Court's opinion in Loper recently, which overruled Chevron and says that the court does not need to show the Chevron-style deference to agencies like the EPA. I mean, Chevron is obviously absent from this opinion. It's not cited anywhere, whereas the court does cite Loper. Can you tell us about how that factors into the court's ruling and what it says for what we should expect from the Supreme Court going forward?
I think that this case shows the wisdom of the Supreme Court moving away from the Chevron deference doctrine to a situation where the federal courts decide the meaning of statutory questions without putting a thumb on the scale in favor of one of the litigants, the regulator. In the time of Chevron, the way that the statutory interpretation issue would have proceeded is that there would have been a question first is whether the words other limitations are ambiguous. And then if there was a conclusion that it was ambiguous, then the question would have been whether the EPA's interpretation of this word is reasonable. And that would have, the opinion applying Chevron for this case would have looked quite different than what this looked like, which is here you have a traditional statutory interpretation case. You look at text, context, and all of that. And the court just tells both the regulated parties and EPA what the rules of the road are without putting the thumb on the scale in favor of EPA or the regulated parties. And, the court doesn't spend a lot of time on Loper Bright. It just cites it. But I think that's a good thing. It just says, hey, Loper Bright, we're just doing the textual thing. And then it does the textual thing like it does in any other case involving a statute. So the court is acting as a neutral arbiter, carrying out its constitutional and statutory responsibility to say what the law is. Obviously that doesn't mean that the answer is clear. Obviously you have a dissenting opinion and you have a majority opinion, but you don't have an opinion where one of the two sides was given a non-textualist leg up in the fight.
Yeah, and it's no secret that Justice Alito and other justices as well have been resistant to the idea of deferring to the EPA in particular in past cases. And there's a great quotation from Alito where, by my reading, he kind of sarcastically jokes about the EPA's expertise. Specifically, when rejecting one of the EPA's arguments that without end result limitations, the EPA has no good course of action to enforce the Clean Water Act, where regulated entities fail to provide requested data necessary to assess compliance with other standards. Alito says, quote, "In any event, the EPA possesses the expertise, which it regularly touts in litigation, and the resources necessary to determine what a permittee should do." I mean, if I'm reading that correctly, it seems as though he's kind of poking fun at the idea that the EPA claims this expertise, and yet, of course, through the citation to Loper, he's not deferring to it. It seems like he's kind of relying on the expertise as a way to say that, we don't have to concern ourselves with the reality that the EPA doesn't have any other good course of action, and yet also not going to let that expertise influence his interpretation of the statute. Does that seem fair?
Yeah, I mean, look, it is a bit rich for EPA with this giant agency having so many resources when it's dealing with individual discharger over whom it has so much power to say, oh, we're going to be powerless. I mean, certainly, I guess the Solicitor General felt like she had to put that in her brief, but as folks who practice in front of EPA, both in regulatory context and litigation context, for EPA to say, woe is me, we lack resources, I mean, I think that's not facially credible.
So, and just for our listeners, if anyone's more interested in hearing more about this issue of deference and Chevron-style deference and Loper, you should check out another episode of this podcast series, an episode called The Relentless Attack on Chevron-Style Deference. Let's just talk a little more about the dissenting opinion here. Justice Barrett's dissent in this case surprised many. Of course, she's a Trump appointee and typically sides with the conservatives in the court. But in this case, she sided with the court's liberal minority. And this isn't the first time she's sided with the liberal minority on an environmental case, right? So what do you think this tells us about Justice Barrett's views on environmental law and her relationship with the conservative or liberal wings of the court?
I mean, I wouldn't overthink the import of her vote in this case. While I think it is very clear that when Congress enacted the Clean Water Act, it didn't intend anything like what EPA argued here. It is true that the statutory text is opaquely written and does, and could be susceptible to the interpretation that Justice Barrett found convincing. I think that the way I would explain her vote here is that she read the statutory text differently than the majority. I think that these lineups that do not ideologically align perfectly are happening fairly regularly. The liberal justices are often the majority, and sometimes it's with, or even when they're in dissent, they have a vote with them. Sometimes it's with Justice Barrett joining them. Sometimes it's with Justice Kavanaugh or Chief Justice Roberts. Sometimes it's with Justice Gorsuch and Justice Thomas. And there hasn't been too many with just Justice Alito with the liberal justices, but it just shows that while there is obviously talk in the press about a 6-3 court, and certainly on certain constitutional ideological matters, it comes to the fore more commonly. The justices are taking each case that they keep their own counsel. They work with their own clerks and they think through it themselves. And sometimes they're just going to reach a result that doesn't line up with where the public consciousness would have it. I mean, but if you think about this case, obviously you have the city of San Francisco versus EPA. The city of San Francisco is not generally known as getting a lot of votes from the conservative part of the court, to the extent they're submitting amicus briefs, they're often on the liberal side. I wouldn't overthink it too much in terms of where she's going to be in other cases, other than the fact that she is an independent thinker. She's not going to always vote on the quote-unquote conservative side. She is going to make her best judgment about what the law requires, which I think is true for all the justices. Of course, a lot of times justices end up coming down one way or the other because their methodology, might lead to a certain result that might align with certain politics in the real world. But in the end, I'm never surprised when one of the quote unquote conservative justices joins the liberals in a case that, where there are fair arguments on both sides.
Before we wrap up, let's look into the future a bit and see how is this case going to impact the parties going forward. So, focusing on the regulated entities here, there are other entities that have end result permits right now, or at least used to before they were invalidated. After this opinion, what happens for those entities? Are those permits invalid now, and does that leave them free to pollute without limitation, or how do we interpret their obligations now after this opinion has been issued?
No, I mean they need to comply with their effluent and their narrative limitations that they have for decades since the Clean Water Act. The what happened is that EPA has been throwing these end water quality conditions within broader permits for quite a while, and those conditions are now inoperative. But the rest of the permits, still stand. And as a practical matter, that's the way that the companies have been operating because the end water quality requirements were just there as a loaded spring gun to help ensnare companies that were doing the right thing, but just following all their effluent limitations. But some problem happened with the receiving waters, often not their fault, and then it generated the opportunity for a citizen suit or whatnot. Now you still got your detailed effluent limitations, your narrative limitations, and you got to comply with those. And I haven't seen any suggestions or data that this has caused a practical problem with water quality anywhere in the nation.
Well, so in this case, one of the EPA's arguments was that an end result limitation was necessary in part because San Francisco was failing to provide the data that would be necessary to assess whether it was complying with the effluent standards. And so, assuming that that happens more often, as I think the majority of these opinions said actually is somewhat common, how is the EPA supposed to regulate these entities if the entities are now only held to the effluent limitations, and yet if they don't produce data, we don't know if they're complying with those limitations?
The Clean Water Act has very powerful remedies that both EPA and citizens can take against those that do not comply with their permits. It is, I think, not a realistic understanding of the way that the entities that generally have NPDES permits, which are sizable businesses, municipalities operate, to think that they would not follow the NPDES permits in hopes that they're not going to get sued, because the liability towards those companies, if they're not protected by the permit shield, is quite substantial. Now, it's true that in all areas of law, if you break the law, you're not going to get caught 100% of the time. I mean, that's one of the criticisms of the Fourth Amendment, I guess. But like the Clean Water Act builds in very powerful tools, which all dischargers know exist for both the agency, but also for private citizens to use if there is a violation. So I'm not saying that there are no violations, that there weren't violations before, but as a practical matter, to think that the Clean Water Act is going to go under-enforced is not, in my respectful submission, a serious concern.
Yeah, and just to make that a little more concrete, this case was about the Oceanside facility that was pumping pollutants out into the ocean, but San Francisco also has a Bayside facility, and I believe the court mentions that with respect to the Bayside facility, there is a litigation going on where the city of San Francisco is looking at possibly $10 billion of in terms of liability for violating its permits here. And so you're absolutely right that the stakes are very high for these municipalities or other entities are held to this standard, assuming that it can be enforced, and which requires the data that we were talking about earlier. Just one last question. How do you think this decision fits in with the broader trends of environmental regulation and the judiciary's role in shaping environmental policy?
Yeah, I mean, I will loop back on the discussion we had with Chevron and Loper Bright. In the era of Chevron deference, not so much in the last couple of years where the U.S. Supreme Court had essentially acted as if Chevron didn't exist and cited it and made its decisions, but in the kind of the halcyon era of where Chevron was at its apex, the agency EPA, and in some cases the Army Corps of Engineers, because it also has authority under the Clean Water Act, had a outsized role in shaping the meaning of environmental statutes like the Clean Water Act, because it had that Chevron deference, and because under Brand X it could change as administrations changed. It could change essentially the meaning of statutes by invoking Chevron deference to go one way versus the other. Now, in the era of Loper Bright, and as a practical matter, in the last couple of years of Chevron, when Chevron wasn't really being used at the U.S. Supreme Court, the courts are now the ones that are setting the guardrails on what the statutes mean. And both agencies and regulated parties need to work within those guardrails. You no longer have a situation where the agencies have an ability to nudge or significantly change the guardrails. It's now a situation where, in Chief Justice Roberts' famous metaphor, the courts are calling the balls of strikes, and they're also interpreting what the rules of the game are, and EPA and regulated parties have to play within those rules.
All right. Well, thanks so much, Misha, for talking us through this important new case. I've been here with Misha Tseytlin, and again, I'm Tim Kelly. Thanks so much for listening.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.